Hey everybody, how you doing? I'm doing a video here today out in the desert. Little change of scenery for my subscribers, hopefully. Hope you guys like it. Anyway, sorry if the sun gets a little bit of a problem there sometimes. Anyways, so we're here today, basically continuing on in my thread, talking about the arguments that the state has made in its first written brief regarding coercion and its argument about coercion. Specifically, this case is going to be in regards to Woods versus Clusen. This is a case that was deemed, the Seventh Circuit Court deemed that it was an involuntary confession, and that they upheld the habeas relief that he had gotten. So they basically affirmed it. So anyways, that's what we're talking about here today. There's some interesting things about this case, obviously, that make it kind of interesting. But mainly, there's two things that this kid had in common with Brendan. Number one, he had no previous contact with law enforcement or the Department of Justice at all. Nothing. He was completely clean up until this point when they arrested him for this. The other thing is that they have absolutely no evidence tying Woods to this. There's no actual physical evidence, just like Brendan, just like it. So now there are dissimilarities between this case and Brendan's, and we'll get to that in a second. But some of the things about this case that were pretty disturbing. This kid was being questioned for hours, right? And several hours into the interrogation or whatever, he was just being silent. He wouldn't answer their questions. He was just, he didn't know what to say to him. I mean, when you read some of this, the summary of this, it mainly points out that he acted kind of bewildered and like he didn't have any understanding of what they were trying to say or accuse him of. So he was really just being silent. He wasn't saying anything. And one of the things said in the summary of this case that was brought up by one of the justices is that you can't grill a silent suspect. You can't do that. You're not supposed to do that. So one of the things that got brought up here. So anyway, I thought I'd bring that up. So and then the other thing about this case that makes it a little different than Brendan's is that in this case, the justices and stuff, they found that the police, the law enforcement involved here, they were just they were very degrading to Mr. Woods. And the reason why they deemed that is because Mr. Woods was arrested. Number one, he was arrested for the theft of a chainsaw that was completely unrelated to this murder case or whatever. That was just their way of getting him in so that they could start questioning him and grilling him about the murders that they suspected him of committing. And when they got him there, they took all of his clothes because they said they wanted those for testing or whatever. And they gave him back some clothes, but they're jailhouse clothes. They were prisoners' clothes. And they didn't give him any shoes. So he was getting interrogated for hours, had fresh interrogators brought in on him hours in, and all this time he's sitting there in jailhouse clothes and no shoes. So this is some of the problems that the judges of the Seventh Circuit found with this particular case with Mr. Woods. And like I said, this is a confession that they deemed was involuntary, and they upheld the district court's ruling for habeas relief. So I'm gonna go ahead and show you now some of the documents, some of the stuff, the information regarding this case. As I always do with the documents, So I'm gonna show you some of the stuff about this case here coming up, and then we'll come back and we'll talk a little bit more.
Okay, petitioner Burnett Woods pled guilty and was subsequently adjudged guilty of second-degree murder and manslaughter in the Circuit Court for Shawanoe County, Wisconsin, for the beating death of Henry and Beryl Schwab. An oral confession obtained from Woods while in police custody played a pivotal role in petitioner pleading guilty. Prior to pleading guilty, Woods brought a motion to suppress the oral confession. The trial court denied the motion. Woods took direct appeal to the Court of Appeals of Wisconsin pursuant to Wisconsin Statute Section 971.31. The Court of Appeals affirmed in an unpublished order. Subsequently, the Wisconsin Supreme Court reviewed the circumstances surrounding the confession and affirmed the rulings of the lower tribunals. See State versus Woods. Woods then petitioned for habeas corpus relief pursuant to 28 U.S.C. Section 2254 in the United States District Court for the Eastern District of Wisconsin. Judge Myron Gordon applied a totality of circumstance analysis to the facts surrounding the obtaining of the oral confession and concluded the police violated federal constitutional safeguards. He granted habeas corpus relief. We now review the district court ruling pursuant to 28 U.S.C. Section 1291. We affirm Judge Gordon's ruling. So this is basically the opening thing, stating what has gone before in the courts with this case and what is essentially happening now. It's basically saying at the end there that they do end up affirming Judge Gordon's ruling, the district court granting the habeas relief. So, but then but this is just the opening, kind of giving you an understanding of what was going on with this case. And what courts it went through and everything before it eventually found its way to success with getting habeas relief. So anyways, that's that. We'll move on to the next bit.
So what we're getting to here now is this case is a little bit different than Brendan's, but I think it's important to consider the AEDPA's guidelines or whatever for determining false confessions. So if you've been watching my other videos and stuff, you'll know that I've brought this up before. This AEDPA thing. So what it comes down to is it's a number of factors they use to determine whether or not a suspect was able to make a conscious decision on whether or not to waive their Fifth Amendment rights and stuff. So I'll go over those items right now again here. They're basically age, experience, education, background, intelligence, the ability to understand a warning given, and the ability to understand what it means to forfeit your Fifth Amendment right and your basically your right to remain silent. So that's what it is. That's what it's talking about. Those factors are trying to determine whether or not a suspect was in a proper place to be able to make a confession. So that's what it comes down to. And the fact is that this case is a little different than Brendan's, because in this one it was about the degrading nature of the interrogation that the law enforcement pursued with Mr. Woods here, and that ended up being one of the circumstances in the totality of the circumstances of those things that I just listed to you that ended up making Mr. Woods' confession involuntary. So with Brendan, it's going to be a little different. It's going to be having more to do with his education, and I think the factors of being able to understand what it means for him to waive his Fifth Amendment right and his right to remain silent and stuff. I don't think Brendan understood those things, and it's clear that he didn't, because he expects to go back to 6th period, and then when he's told no, he's being arrested, he says, "Is it only for one day?" Clearly did not understand what was going on. I mean, that's blatantly obvious. So that'll be this segment. We're going to move into the next set of documents here, and then we'll come back one more time, and then we'll finish it up.
A review of the totality of the facts and circumstances surrounding this case does not leave us with the impression that the constitutional principles and values enunciated by the Supreme Court above were respected in any acceptable manner. The police simply overreached in this case. We note the following particulars to be reviewed in a totality of circumstances framework. Petitioner Woods was a juvenile, 16 and 1/2 years of age. He had no prior criminal record and certainly no serious previous contact with the criminal justice system. He was awakened early one morning by police officers hovering in his bedroom, handcuffed and led away from his home and family in a matter of moments, ostensibly for the theft of a chainsaw. Upon his arrival at the police station, he was stripped of his clothes, given institutional garb, but not given shoes, enhancing his feelings of powerlessness and vulnerability. Woods was fingerprinted and photographed and led to an interrogation room where, once seated, he was immediately confronted with graphic, if not gruesome, pictures of the Schwab murder scene. Woods was then subjected to an extensive 15 to 20 minute interrogation by two experienced adult police officers to which he never consented, except for one statement which police officials would be quick to admit was an obvious slip. Woods obviously had little inclination to speak to either one of these officers. With this in mind, his silence, when asked if he would like to talk, could just as easily be read as confusion and a lack of understanding as to what was happening and what to do. The officers also intentionally made misrepresentations to Woods about the sufficiency of evidence against him. Officer Trumby's statement to the juvenile that it would be better if Woods talked was dubious advice to the ignorant, as any minimally competent defense counsel would be quick to attest. So, you can obviously tell that the judges in this case had a real disdain for the way that the investigators handled this. They clearly had issue with it, and I think that final statement there about as any minimally competent defense counsel would be quick to attest. I mean, that just seems like they're just saying, like, basically any stupid idiot, who knows anything about law at all would know that. But, anyway. So that's what's going on here. That's kind of the what I'm talking about when I talk about the totality of circumstance, how they are taking in a bigger picture to determine a voluntariness of a confession. So that's what I've been talking about.
Okay, so this is pretty much the end of the Woods versus Clusen case law cited by Schimmel in his first written brief. Important things to note really are the fact that the way that law enforcement did the interrogation and stuff like that was very degrading to Woods. That was a huge factor here. And it's important because it gets factored into the totality of the circumstances. I think that's important. The totality of the circumstances of all those factors: age, education, background, whether or not they're capable of understanding what it means to basically forfeit their Fifth Amendment right to remain silent, and if they actually understand the suggestions that are being made to them, that they fully understand all of the implications of what their confession would mean. So it's all of these things all together, all looked at together in what they call the totality of circumstances here that matter. And for this case, the totality of the circumstances went the way of where Mr. Woods was considered to have not been in a fair position to have given a voluntary confession, because the police had been basically so degrading in the way that they were interrogating him, and the fact that he was young and not fully educated yet. Obviously, as I said before, had no previous contact with law enforcement really, or the DOJ at all. These things were all huge factors that matter. So, and all together, all these things all come together and they culminate into the Seventh Circuit Court, obviously, ruling the confession was involuntary. So, and I think that Brendan's got a good case, but Brendan's got there's different points for Brendan. There's different, little subtle differences for Brendan. For Brendan, it's about the fact that he wasn't really at the normal level of a normal 16-year-old at the time. And that's why in this case he wasn't, he wasn't on the same mental level as this kid Woods. He isn't. And that is a factor, and that's going to factor into the totality of the circumstances. And then don't forget about the Mishi Kurai brief, because that thing is going to be a factor. You know, it's going to be a huge factor, huge, I think. So,
in contrast, in the case at bar, we are concerned with a custodial police interrogation involving a juvenile where rather intense psychological pressure was employed. We rule today the police conduct in the instant case fatally tainted the voluntariness of Woods' confession by hindering his ability to make a rational, voluntary waiver of his Fifth Amendment privilege against compelled self-incrimination. We find no need to rule on the state's burden of proof argument, which focuses on the issue of whether the petitioner bears the burden of proving his confession involuntary, or whether the state must prove a valid waiver in a habeas corpus action. We find any discussion on this in this case unnecessary because under either standard advanced by the state, we believe affirmance of the district court ruling is in order. So I just thought that last little bit there was particularly humorous, because they're basically saying, yeah, doesn't matter what you which way you go, state, we basically believe we affirm the district court's decision, and yeah, basically give it up. So I think that's kind of funny here. So anyways, that's it, people. If you haven't already, please hit subscribe, and you have a nice day.